ladies and gentlemen. Welcome and thank you for joining today's HUBZone Joint Ventures Conference. Please note that all participant lines will be muted to reduce background noise during the call. However, throughout this conference, you are welcome to submit written questions, and these will be addressed after the conference has concluded. If at any time you require technical assistance, please right-click on the ATT CES operator to send a note via the software. Otherwise, please use the Notes tab on the bottom right-hand side of your screen and address your question again to the ATT CES operator. Or you can also call our help desk at 888-796-6118. And with that, I'd like to turn the call over to Mariana Pardo, HUBZone Program Director.
Thank you. Good afternoon. My name is Mariana Pardo, and I welcome you to the webinar called Joint Ventures, How You Partnered with Other Companies for HUBZone Contracts. Today, I'm joined by my colleague, Mark Hagedorn. He's an attorney advisor with our Office of General Counsel, and we are going to be going through the benefits of joint venturing in particularly with in the HUBZone, within the constraints of the HUBZone program, the requirements to forming a joint venture, what the agreement needs to have, the joint venture agreement needs to have, limitations on subcontracting and the performance of work requirements for the joint venture, and we will do a brief introduction to the All Small Mentor-Protégé program, because within it you can form also a joint venture. We have some acronyms here. We wanted to give you an idea of what they mean, so you can refer to this later on. We're recording this, and we're going to be placing it in the YouTube SBA channel, so you will have this information. The benefits of joint venturing are obvious to many of you, but obviously it increases the access to federal set-aside contracts, in particular the HUBZone set-asides, because a HUBZone firm can combine the resources, the expertise, technology, etc., with other firms to come in with a stronger position. They can increase their bonding capacity. They also have the opportunity to improve the performance as well as refine technical skills that maybe they don't have at the moment, but in this particular opportunity, federal contracting opportunity that the joint venture hopefully will get the award, they will have the opportunity to refine their technical skills. Obviously, they will expand, either establish or expand their core business capabilities through the joint venture and enter into new markets and customer bases. And the last one, obviously, is the ability to leverage the past performance of the joint venture as well as each individual party to the joint venture. The joint venturing within the HUBZone program, the current regulations in the Code of Federal Regulations, which is the regulations that govern the HUBZone program, it allows the HUBZone small business concern to joint venture with another small business, whether it is a woman-owned small business, service-disabled small business, or they can joint venture with an approved mentor under the SBA 8A Business Development Mentor-Protégé program, or because they got an approved Mentor-Protégé agreement in the All Small Mentor-Protégé program. Remember that we want to highlight that the federal acquisition regulations still contain the old SBA rule. That will be updated in the near future. But under the FAR, the joint venture is still written in the old way, saying that each member to the joint venture must be a HUBZone certified firm, and that each member needs to be small under the size standard assigned to the subject contract, and that the collective size of the joint venture needs to be within the constraints of the size standard of the contract. But Mark will clarify that. As you see, I'm not a contracting specialist. Let us go now into the next slides, which Mark will be concentrated on.
Great, thank you, Mariana. We're going to segue into talking a little bit more about some of the technical aspects of joint venturing as a HUBZone joint venture and going after HUBZone set-aside contracts as well as sole source awards. And so the first point we just want to mention here is that a HUBZone joint venture must be identified as a joint venture in the System for Award Management. And if you're familiar with that, that is sam.gov. So that's where you go on, register your business, and in this case, if you'd like to go after a HUBZone contract as a joint venture, you would have to identify the entity in sam.gov. Just a quick note here that the HUBZone joint venture certification on sam.gov is a self-certification. SBA does not certify or provide HUBZone certification to a joint venture entity. So that is something that you would be self-certifying in sam.gov as well as to the contracting officer. Our regulations state that the government will execute a HUBZone contract in the name of the HUBZone joint venture, if it's its own entity, or in the name of the qualifying HUBZone small business concern that ultimately qualifies the joint venture to go after a HUBZone contract. But in either case, the award will be identified as one to a HUBZone joint venture. And we just want to highlight a quick update here that came out in 2017. The Federal Procurement Data System, which monitors and tracks federal awards, and specifically for our purposes, really helps us track HUBZone goaling to meet the 3% statutory goal for prime contracts going to HUBZone firms. The Federal Procurement Data System has added a new entity feature entitled HUBZone Joint Venture, and so as a result, we anticipate contracting officers making awards to the joint venture itself more than the HUBZone small business concern that ultimately qualifies the joint venture. So we're going to talk quickly about the general HUBZone joint venture requirements next, and unfortunately these requirements are not consolidated in the regulations. Some of them are contained in Part 121 of SBA regulations, and some of them are contained in Part 126. And so I've kind of boiled them down into 5 main points. So the first requirement is that the joint venture agreement must be written, and it must, at a minimum, contain the provisions that are set forth in the HUBZone regulations at Part 126.616C. And don't worry, we're actually going to go over all of those required provisions in the next few slides, so we'll discuss those. The second requirement is that the joint venture must conduct business in its own name. The third requirement is that the joint venture must be identified as a joint venture in the System for Award Management, as we just discussed on the previous slide. If the joint venture is organized as a separate legal entity, such as a limited liability company or a corporation, the joint venture must list all individual partners in sam.gov. I'm sorry, excuse me. If it's organized as a separate legal entity, it must be unpopulated. Excuse me. And that is, contrast that with a populated joint venture where the employees of the joint venture actually perform substantive contract work. SBA regulations no longer allow for unpopulated joint ventures to bid on and win contracts. And so if a HUBZone joint venture is going to bid on and win a contract, the individual parties to the joint venture must perform substantive work under the contract. There is one exception. The reason we allow certain individuals to be employees of the joint venture itself is that certain contracts, especially for DOE, require like a facilities clearance officer, and that individual generally has to be an employee of the prime contract. Case would be the HUBZone joint venture, and so that individual can't perform substantive work under the contract, but can certainly be an employee of the joint venture. The last requirement is the size requirement for a HUBZone joint venture. As Mariana already discussed, there are 2 ways to joint venture on HUBZone contracts, and that is between a joint venture consisting of a HUBZone small business concern and 1 or more other small business concerns, as long as each concern is small under the contract. there is also a way where the HUBZone small business concern can joint venture with its SBA-approved mentor. And in that case, even if the mentor is large, the joint venture entity would be accepted from a finding of affiliation because of the provisions in the Mentor-Protégé program and SBA regulations. There's just a quick note right there that these two size requirements are actually exceptions to the general rule that joint ventures are affiliated on a contract-specific basis. Basically, for joint venturing purposes, joint venturers to that joint venture are affiliated on a contract-specific basis. However, there is also a finding of general affiliation if the joint venture receives 3 contracts over a period of 2 years. So if that's the case, those venturers will be affiliated for general purposes, not on a contract-specific basis. So please refer to Part 121, 103, subparagraph H for a little bit more information about the 3 and 2 rule if you have questions about both contract-specific and general affiliation. So next we're going to talk about the contents that have to be included in a HUBZone joint venture agreement. And as I mentioned earlier, these are set forth in the HUBZone regulations at Part 126.616C if you'd like to take a look for yourself. But these regulations state that every joint venture agreement to perform a HUBZone contract must contain a provision that sets forth the purpose of the joint venture. For SBA purposes, joint ventures are limited purpose entities, and they're formed for the specific purpose of going after a specific contract. So the first provision would set forth that purpose and the specific contract at issue. Each joint venture agreement must also designate the HUBZone small business concern as the managing venturer of the joint venture, and the employee of the HUBZone managing venture must be the project manager responsible for performance of the contract. It's important to note that the project manager who is responsible for performance need not be an employee of the HUBZone managing venturer at the time of initial offer, as long as there is a letter of intent executed between the HUBZone managing venturer and the project manager who's responsible for performance. However, if it's a joint venture that's formed with a SBA-approved mentor and it's HUBZone protege, the project manager who's responsible for performance cannot be a former employee of that mentor. And so that's a restriction that's contained in the regulation. So just be aware of that when you're executing this agreement. The third required provision is that the agreement must state that the HUBZone small business concern, and that could be 1 if it's a joint venture that's between a HUBZone firm and its mentor, or it can be 2 or more if it's a HUBZone joint venture that's formed between multiple HUBZone firms and other small businesses. But the provision requires that the HUBZone firms own at least collectively 51% of the joint venture entity. The fourth provision is that the HUBZone partners must receive profits from the joint venture commensurate with the work performed by the HUBZone small business concern partners to that joint venture. The fifth required provision is that the joint venture must establish a special bank account that is specifically in the name of the joint venture. And just a quick note at the bottom there, all withdrawals will require the signature of each party to the joint venture, and that is both HUBZone and non-HUBZone members to the joint venture. And please pay special attention to that requirement because that, as we'll discuss later, could serve as a basis for suspension and debarment, not following that withdrawal signature requirement. The sixth item that must be included in a HUBZone joint venture agreement is that provision must itemize all major equipment, facilities, and other resources that are going to be furnished by each member to the joint venture with a detailed schedule of cost or value of each, if practical. And I'll just borrow the note from the seventh provision here to state that this really does need to be sufficiently specific if the requirements are known at the time of initial offer. And this would be especially where the itemization of costs for major equipment are required in preparation of pricing in submitting the bid. So if it's a construction contract where the requirements are known up front, we would expect this itemization of all equipment and facilities to be fairly detailed. In contrast, if it's like a multiple award contract where some of the task orders up front are not quite known at the time of initial offer, this is something where we would expect more of a general description of major equipment and facilities. So just be aware of that. Along the same lines, for Provision 7, the joint venture agreement must specify the responsibilities of each party with regard to contract negotiation, the source of labor, and contract performance. And I just underscore here that this provision must specify how the parties will ensure that the joint venture and the HUBZone partners will meet the applicable performance of work requirements. We'll talk about those a little bit later in the presentation, but basically there are performance of work requirements that are applicable to the HUBZone venturers that are a part of that entity. And so at the time of execution, the parties have to get together and write a detailed description of how they are going to meet those performance of work requirements. So at the end of the contract, we had at least a basis for knowing up front. So, and similar to the itemization of all major equipment, if the requirements are unknown at the time of initial offer, such as an IDIQ contract or a multiple award contract, the joint venture agreement must just provide a general description of the anticipated responsibilities of each party and how basically the performance of work requirements will be met once those requirements are more definite or the scope of work is available. The 8th required provision of a joint venture agreement to perform a HUBZone contract, and this is more just a matter of contract administration and contract law. It must obligate all parties to the joint venture to ensure performance of the HUBZone contract if one of the joint ventures withdraws from the agreement at any time. The 9th required provision must designate that accounting and administrative records relating to the joint venture be kept in the office of the managing HUBZone small business concern. That's pretty straightforward, but it's got to be in there, and records have to be with the HUBZone managing venturer. The 10th required provision is that the HUBZone small business concern managing venturer must retain all final original records related to the JV and the contract. Again, similar to 9, but at the end of the contract, all of the original files have to stay with the HUBZone managing venturer. The 11th required provision states that the joint venture has to submit quarterly financial statements showing cumulative contracts, the receipts and the expenses no later than 45 days after the operating quarter. And this is something that has to be submitted to SBA. And it must include the salaries of all joint venture principals. And again, this is to ensure that the HUBZone joint venture is complying with the requirements of the joint venture agreement, which states that the work, the salaries, all have to be commensurate with the work done by the HUBZone members of the joint venture. And the last required provision of a HUBZone joint venture agreement states that the project and profit and loss statement, including a statement of the final profit distribution, has to be submitted to SBA within 90 days after contract completion. Again, pretty straightforward. So this is not an exhaustive list of all the provisions that can be submitted for or can be executed in a HUBZone joint venture agreement. You can really submit anything that works for your parties, for your specific joint venture, to the extent that it's not inconsistent with these required 12 provisions. So the sky's the limit as long as it's not inconsistent with what we just discussed. We may have discussed a little bit earlier, but just a note down at the bottom that SBA does not approve HUBZone joint venture agreements. It's up to the parties to execute an agreement that's consistent and in accordance with the regulations that we just discussed. But it is important that parties execute an agreement that's in compliance with these regulations because SBA or the contracting officer will review the agreement for compliance to determine eligibility in a size or a HUBZone status protest. So in the HUBZone status protest context, if there's a provision that's missing or flawed, SBA would determine that the joint venture entity is not eligible to win the contract. If it's in a size determination, if the HUBZone joint venture agreement's missing or missing one of the provisions or has a flawed provision, that entity would not be eligible for the exception to affiliation. And so there could be some size concerns there. So please note that it's very important to execute a joint venture agreement that's consistent with SBA regulations. We're going to talk about some miscellaneous and other joint venture requirements. SBA regulations state that, and specifically the HUBZone regulations, state that in order for a HUBZone joint venture to be eligible for a HUBZone contract, each HUBZone small business venturer must be qualified at the time of initial offer and the time of award, and must certify to the contracting officer that it is a qualified HUBZone small business concern that appears on the list, and that list is the dynamic small business search on it, through SBA's platform. The second certification is that there have been no material changes that could affect that firm's HUBZone eligibility. The third required certification is that the firm is small under the NAICS code assigned to the contract. And the fourth one, very importantly, is that the firm will attempt to maintain the required percentage of HUBZone resident employees during performance of the contract. We'll cover this in, I guess, some future webinars, but just kind of as a preview, there is a 35% HUBZone residency requirement that's generally applicable to HUBZone concerns as an element of HUBZone eligibility. Our regulations do, and the HUBZone Act actually, they both allow for firms to dip below this number in performance of a HUBZone contract, provided that the firm is attempting to maintain the required provision. So that's the last certification there, but again, we'll talk about that in future webinars. The note down at the bottom is that for HUBZone status protest, SBA will review the HUBZone joint venture agreement at the time of offer, initial offer, and at the time of award if there have been changes to the joint venture agreement in between those times. So if the HUBZone joint venture agreement had something that was not included at the time of award, we would look to make sure that the agreement was at least compliant at both times in issuing a HUBZone status protest determination. So please keep that in mind. Some additional other joint venture requirements, and these are actually in the joint venture regulations in the HUBZone regs. So each HUBZone small business managing venture, prior to the performance of a contract, must submit a written certification to the contracting officer and SBA signed by each member to the joint venture stating the following. That the parties have entered a joint venture agreement that fully complies with the regulatory requirements in Part 126.616, those 12 required provisions that we just discussed, and that the parties will perform the contract in accordance with the joint venture agreement, the limitations on subcontracting, and the performance of work requirements. And again, I'll just highlight here that SBA doesn't approve HUBZone joint venture agreements, and that the contracting officer will accept self-certifications of compliance, as we just discussed. But again, there are consequences to not entering into an agreement that's compliant or performing that agreement in compliance with the HUBZone regs. I think these are the last miscellaneous joint venture requirements that we're going to discuss, but inspection of records. The joint venture partners must allow SBA, including SBA's Office of Inspector General, to access and copy all records and documents related to the joint venture. In addition, there are certain performance of work reports that the HUBZone managing member must submit annually to the contracting officer and SBA, signed by each venture, explaining how performance of work requirements are being met if the requirement is, or if the period of performance exceeds 1 year. And in addition, there must be a final performance of work requirement that's due to SBA and the contracting officer, detailing a written certification that the contract was performed in accordance with the regulatory provisions, again, that we've already discussed. So those are the required elements of joint venturing in the HUBZone program. We're going to move next into the HUBZone limitations on subcontracting. This was a topic that we discussed a little bit in our last webinar, and we're going to discuss how it specifically applies to HUBZone joint venture entities. The regulatory provisions, if you're interested, are in SBA regulations at Part 125 and 126 and 700. There are a couple cross-references in there, so it's mainly 125 and 126. This is also in the FAR, but I'll just note here at the end that the FAR updates are forthcoming. They are not currently consistent with SBA's most current rule, so I'll just at the end explain the difference between SBA's current rule and the FAR rules. So as a prime contractor receiving a HUBZone contract, the joint venture entity itself must meet the applicable limitations of subcontracting. And basically, in a nutshell, what these limitations on subcontracting do is they restrict the amount that a HUBZone joint venture may subcontract out to a firm that is not similarly situated, and that is expressed as a percentage of the total amount paid by the government on the contract. So the restriction varies based on the contract type. For services and supplies, there is a limitation of subcontracting of 50% of the total amount paid by the government. For general construction, it's 85% of the total amount paid by the government, and for specialty trade construction, it's 75% of the total amount paid by the government. So for our purposes on a HUBZone contract, a similarly situated entity is another subcontractor with HUBZone certification. So that would be a HUBZone small business concern. So if there is a portion of the contract that is subcontracted out to a HUBZone firm, that is not counted against the prime contractor's limitations of subcontracting. This is a little bit different, as I mentioned, than what is currently in the Federal Acquisition Regulation. The limitations on subcontracting in the FAR operates a little differently in that it requires the prime contractor to spend a certain percentage of the cost of the contract on its own personnel, but it doesn't specify anything or give any benefit to work that's subcontracted out of a similarly situated entity. There is a current open FAR case that's implementing SBA's new limitations on subcontracting. I believe it was actually up for debate today, so hopefully we'll see the new rule come out as soon as possible. But just please note the distinction. We're constantly educating contracting acquisition teams of SBA's new rule, but there are probably some teams out there that will still apply the rule contained in the FAR until it catches up with SBA regulations. So please just know the difference. We're going to next talk about the HUBZone performance of work requirements applicable to HUBZone joint venture entities that I discussed. And these generally state that the HUBZone partners to the joint venture collectively must perform at least 40% of the work performed by the joint venture itself. So the limitations of subcontracting apply to the prime contractor, which is, again, the HUBZone joint venture entity. The performance of work requirements are expressed in terms of how much the HUBZone partners must do in relation to the work performed by the joint venture prime contractor. So SBA regulations state that the work performed by the HUBZone partners must be more than administrative so that it gains substantive experience in the joint venture or from the joint venture activities, And this is just to ensure the purpose of HUBZone joint venturing so that the HUBZone partners actually gain something from the joint venture and from performing under the contract. In addition, the aggregate of the HUBZone partners to the joint venture or the collective amount of the work done, not each concern separately, must perform the applicable percentage of work requirement. So that means that SBA will count all the work done by all HUBZone members to the joint venture in determining whether that 40% performance of work requirement is met on a particular contract. There is just a quick note down there at the bottom. For HUBZone joint ventures between a HUBZone protege and its mentor, all work done by the mentor and any of its affiliates at any subcontracting tier will be counted in determining compliance with the HUBZone performance of work requirements. And that's just to ensure that the protege is getting substantive value and experience from the contract, and it also maintains the integrity of the mentor-protege program. Quick note on suspension and debarment. This is something that's actually contained in SBA regulations, so I would direct you to check out our regulations at Part 126.616 if you have any questions or would like additional information. But SBA does view compliance with the HUBZone joint venture regulations as an element of present responsibility, and the regulations state that SBA, or the government for that matter, but for our purposes SBA, may consider the following as grounds for suspension and debarment as willful violations of a regulatory provision or requirement applicable to a public contract or agreement. And that would be a failure to enter into a joint venture agreement that contains all of the regulatory provisions that we've discussed at length, a failure to perform a HUBZone contract in accordance with the joint venture agreement, the limitations on subcontracting or the performance of work requirements, a failure to submit the required certifications to SBA and the contracting officer, or denying SBA access to the joint venture records or documentation. These are all bases for suspension or debarment. So SBA takes them very seriously, and if you're not aware, a suspension or debarment would prevent any future government contracting at the prime or subcontracting level. So there are some pretty severe consequences to not following SBA regulations. So that's all we have on HUBZone joint venturing today. Because we talked about joint venturing with an SBA-approved mentor, we just wanted to give a quick overview of the All Small Mentor-Protégé program. It's a relatively new program that was modeled after the highly successful 8A Mentor-Protégé program. It has a very similar purpose and operates in a very similar way. So if you're familiar with that program, a lot of this information will not be new to you. But we just wanted to go over the All Small program and some of its nuances so that if you are interested in joint venturing with an SBA-approved mentor, this is how you could get started. But this is really just an invitation to go out and seek additional information either from SBA's website or the All Small Mentor-Protégé program office. The purpose of the All Small Mentor-Protégé program, very similar to the 8A Mentor-Protégé program, is to develop the capabilities of protégé firms through mentor-provided business development assistance and to help protégés successfully compete for government contracts. An SBA-approved mentor can provide assistance in many forms, which can include but is not limited to management and technical assistance, things like management systems, marketing assistance, technology transfers, manufacturing assistance. They can provide financial assistance in the form of investments in the protégé as well as loans or help with bonding capabilities. A mentor can help with contracts, and that includes pricing strategies or proposal drafting. But as we've already discussed in the joint venture, in the joint venture context, they can help with performance as well. They can help with trade or industry education, finding markets, learning how to export your capabilities. They can provide business development assistance, and they can provide also general or administrative assistance such as payroll or human resource sharing. They can help with, they can sponsor a firm for obtaining a facilities clearance. So all of those things are, again, that's not an exhaustive list, but those are some of the more common forms of business development assistance that a mentor can provide to its protégé. So in addition to all of those business development forms of assistance that we just discussed, there are a couple additional benefits to participating in the All Small Mentor-Protégé program. As we kind of discussed a little bit earlier, there is an exception to affiliation. And what that means is that SBA will not find affiliation based solely on the Mentor-Protégé agreement or the assistance provided under it. However, that does not provide a broad exception to affiliation for all purposes. Our regulations state that affiliation may be found for other purposes, and this is not an exhaustive list, but if you look at Part 121, 103 in SBA's regulations, you can see all of the grounds for a finding of affiliation. For our purposes, some of the more common ones would be perhaps an identity of interest between the mentor and the protégé, ostensible subcontracting, where if the protégé is unduly or unusually reliant on a mentor for contracting. Also, the affiliation based on the totality of circumstances. Again, these are just some of the grounds for affiliation that can be found between a protégé and its SBA-approved mentor, notwithstanding the approval of SBA. So the third big benefit to participating in the All Small Mentor-Protégé program is joint venturing. So as we already discussed, a protege and its mentor may joint venture as a small business for any government prime contract or subcontract so long as the protege qualifies for the procurement in question. And just a quick example here, if a firm has both HUBZone certification and certifies as a women-owned small business, if that firm's a protege, then it can joint venture with its mentor on any small business set-aside because it qualifies as small. It can joint venture for a HUBZone contract, or it can joint venture on a WOSB contract as long as the protege is small under the procurement. So again, this is if there was 8A certification involved, the protege and the mentor could joint venture after an 8A contract. This was just an example, but anytime the protege qualifies for the procurement, the mentor and its protege may go after that as a joint venture. Just a quick note, as we already discussed, the joint venture agreement between a mentor and a protege must contain all the required provisions in order to receive the exception to affiliation. So again, look at Part 125 for the All Small program for the list of required provisions. If it's a HUBZone contract, look at Part 126. We're just going to give you a brief overview on applying to the All Small Mentor-Protégé program. Quick note here, the All Small Mentor-Protégé program is not a matching program. It doesn't match prospective protégés with possible mentors. This is a relationship that must first be established by the protege and the mentor before applying to the program. But once that relationship has been established, all prospective parties must go to SAM.gov and register prior to filling out an application. If both parties were government contractors, likely they will be registered in SAM.gov, but if this has not happened yet, this is a step that needs to be done before application. All prospective proteges and mentors must first complete an online training module as part of the application process. And you can go to SBA's website to find out a little bit more and actually complete the training module. But this just provides a little bit more information on the program itself and might answer some of the questions that you have about it. All applications are received through the new certify.sba.gov platform. So if you just go to that website, it will walk you through step by step on how to fill out an application to the All Small Mentor-Protégé program. Last but not least, the mentor and the protege firms must first execute a written mentor-protege agreement governing the mentor-protege relationship. We're going to talk about this and what is required in the mentor-protege agreement, so stay tuned. But if you're looking for a sample that you can use, it's not one that you have to use, but one that you could use as a template for constructing your mentor-protege agreement. You can just go to that website right there on SBA's main site. Next, we're going to talk about some of the protege eligibility requirements, and these are contained in Part 125 of SBA regulations, if you'd like to take a closer look. But the first eligibility requirement is size. In order to qualify initially as a protege firm in the All Small Mentor-Protégé program, the prospective protege must qualify as small under the size standard corresponding to its primary NAICS code. Or there's another way to come in, and that's to have the protege identify that it's seeking business development assistance in a secondary NAICS code, not its primary, for which it qualifies as small. However, the firm must demonstrate how the mentor-protege relationship is a logical progression or expansion of its current capabilities. So SBA won't just blindly approve a mentor-protege relationship if the protege has absolutely no prior work experience or capabilities in the secondary NAICS code for which it's seeking to qualify as a protege. If you have questions about whether your firm qualifies as a small business concern, there is some information on SBA's website. You can go to the size standards tool, or you can also refer to Part 121, which is the regulation, the part in our regulations governing size standards. And so that not only includes how SBA calculates size, but also the size standards that are applicable to each industry code. Continuing on with some protege eligibility requirements here. In general, SBA regulations state that a protege may only have one mentor at a time. SBA may, however, approve a second mentor if the second relationship does not compete or otherwise conflict with the assistance being provided under the first mentor-protege agreement, and the second relationship pertains to an unrelated NAICS code, or if the protege is seeking specific expertise that the first mentor cannot provide. So these are demonstrations that the protege has to meet in order to qualify for a second mentor-protege relationship. So questions about those requirements, please feel free to reach out to the All Small Mentor-Protege Program Office, and they'd be happy to field any questions. Quick note for 8A firms. As we already discussed, the 8A Mentor-Protege Program is a distinct program from the All Small Mentor-Protege Program. However, if you are an 8A participant out there in the last 6 months of your 8A program term, 9-year term, if you're in the last 6 months of that term, you may transfer your existing 8A Mentor-Protege relationship to the All Small Mentor Program by simply notifying SBA. In that case, no approval or reapplication will be necessary. You just become a member or a participant in the All Small program. Great, so we finished up discussing the protege eligibility requirements. We're just going to move in and talk about the mentor eligibility requirements. And again, these are set forth in Part 125 of our regulations if you'd like to take a closer look. So to qualify as a mentor for the program, a concern must demonstrate that it's capable of providing the agreed upon business development assistance that is laid out in the mentor-protege agreement. Each mentor must possess good character. It cannot be presently suspended or debarred. And it must demonstrate that it can impart value to the protege firm due to practical government contracting experience. However, unlike with the protege eligibility requirements, there is no size eligibility requirement for mentors. So a mentor can be a small business concern. It can also be a large concern, or one that exceeds the size standard for its primary NAICS code. Quick note down there at the bottom, however, once approved, a mentor must also annually certify that it continues to possess good character and has favorable financial health. So that's an annual certification that must be made to SBA. Quick note at the bottom, a small business can serve as a protege and a mentor at the same time if it can demonstrate that the second relationship will not compete or conflict with the first mentor-protege relationship. So this could happen where a protege firm is seeking business development assistance in perhaps a secondary industry that it's trying to expand capabilities in, but it might already have a very strong hold in its primary industry. And if that's the case, it could certainly qualify to be a mentor. But again, it just would have to demonstrate to SBA that that second relationship would not compete or conflict with the first relationship. So as promised, we're going to move in and talk about what are the required elements that must be contained in the mentor-protege agreement itself. This is outlined in SBA regulations, Part 125 if you're curious, which state that the mentor-protege agreement must outline the protege's business development needs as well as a detailed description and timeline for the delivery of the agreed-upon business development assistance. At a minimum, it must address how the assistance to be provided will help the protege meet its goals as defined in the protege's business plan. It must establish a point of contact in the mentor responsible for implementing the provisions under the mentor-protege agreement. It must state that the mentor will provide business development assistance to the protege for at least 1 year, and it must state that either party can terminate the agreement within 30 days' notice to the other party, as well as SBA. Similar to the 8A Mentor-Protege program, SBA must approve the Mentor-Protege agreement as part of the application, and it must also approve any subsequent amendments to that Mentor-Protege agreement. The agreement itself may not exceed 3 years. However, if the parties wish and SBA agrees that it's in the best interest of those parties, the agreement may be extended for an additional 3-year term or 6 years total. So the next slide is going to discuss an application where SBA has actually declined the Mentor-Protégé Agreement. And if that's the case, the protégé may request reconsideration of SBA's determination or may revise the Mentor-Protégé Agreement to provide any additional information or documentation that would be pertinent to overcoming those initial grounds for decline. It's important to note here that the request for reconsideration must be received by SBA within 45 days of the initial decision declining the Mentor-Protégé Agreement. SBA will, in turn, then issue a reconsideration decision within 45 days of that request. If there are new grounds for decline in the reconsideration decision, the protégé may request reconsideration as if it were an initial decline, and then subsequently request reconsideration if that decision was ultimately turned down by SBA, or I'm sorry, if the agreement was turned down by SBA. Just a quick note here at the bottom, if the final decision is ultimately to decline the Mentor-Protégé Agreement, the protégé may not apply with the same proposed mentor for 60 calendar days as of the decision. However, the protégé can apply with a new proposed mentor at any time after SBA's decision. So just keep that in mind. There are some annual reporting requirements under the All Small Mentor-Protégé Program. We're just going to go through them here. Again, these are in Part 125 of SBA's regulations if you have any questions. But these state that at a minimum the protégé must annually report all technical and management assistance provided by the mentor during that year, all loans or equity investments that were made by the mentor and the protégé during that year, any subcontracts between the mentor and the protégé, all federal contracts that are awarded to the mentor-protégé relationship as a joint venture, where the joint venture is the prime contractor, as well as a narrative describing how the protégé has benefited from such assistance that was provided over that year. SBA reviews the mentor-protégé relationship on an annual basis to determine whether it gets approved for another year. However, it automatically renews unless SBA rescinds it in writing. So while SBA will look at it each year, don't necessarily expect for an affirmative yes. The Mentor-Protégé Agreement will continue on unless basically otherwise stated by SBA. Please note down there at the bottom that SBA reserves the right to terminate a mentor-protégé relationship if it ultimately determines that the mentor has failed to provide what was agreed upon in terms of business development assistance, or if SBA determines that the assistance has not materially benefited the protégé. These are just some miscellaneous requirements and provisions in the All Small Mentor-Protégé Program. Similar to the 8A Mentor-Protégé Program, a mentor may purchase an equity interest of up to 40% in the protégé firm for the sole purpose of raising capital to benefit the protégé firm. In addition, a mentor may generally only have one protégé at a time. However, SBA may authorize a mentor to mentor additional protégés if the additional relationship will not adversely affect the development of either protégé. And an example of that would be generally where the two protégés would be competitors. That would be a situation where SBA would not approve it. So last year, we're just going to talk a little bit about some of the HUBZone resources that you can find on SBA's website. If you go to SBA.gov and specifically the HUBZone program page, you'll find information about maintaining HUBZone certification, understanding the program requirements, including mini primers on specific elements of HUBZone eligibility and contracting, as well as webinars like the one we have today. The HUBZone program page will also direct you to the map, the certify.gov map, which will show you whether a location is located within a qualified HUBZone HUBZone, and it also will have frequently asked questions about certification, application timelines, as well as supporting documentation. You can find more local assistance on SBA's website too at the websites that are listed here. Again, and so that not only includes servicing district offices close to your firm, but also local partners that could help you with not only your HUBZone application or contracting opportunities, but just could help you with your business development goals and your plans. So please visit that website if you have additional questions. And lastly here, just wanted to highlight HUBZone office hours, which are offered on Tuesdays and Thursdays between 2 and 3 p.m. Eastern Time. If you have any questions about your firm's eligibility and would like to talk to someone in the HUBZone program office, please call that toll-free number. It doesn't look like it's listed here, but you can find it on SBA's website. Or you can also email the HUBZone at SBA.gov inbox if you have any questions about the program. So I think that's it.
Yes, thank you, Mark.
Thank you.
And thank you to everybody who has invested the time. This webinar is concluded.
Thank you all for joining today's conference. The conference has now concluded, and you may now disconnect. Once again, the conference is now concluded, and you may now disconnect.